Wealth management is not just for the wealthy. Everyone is entitled to their best retirement possible. Welcome to The Retirement Engineer with Jim Kruzan, your path to a bigger, bolder retirement. Brought to you by Kaydan Wealth Management, a firm that specializes in serving the mobility technology industry. In this podcast, we help you maximize your resources and engineer your best retirement through a process-driven approach so you can get the little things right. Drawing from years of expertise, Jim and his guests will simplify complex wealth management strategies and explore actionable ideas to help you protect your hard-earned wealth and take control of your future. Now, on to the show.
Today, we're diving into a topic that can dramatically alter the course of your financial future: divorce and its impact on retirement planning. With nearly half of all marriages ending in divorce, the financial repercussions can be profound. I'm Patrice Sikora, along with your host, Jim Kruzan. And in this episode, we will unpack the complexities of divorce, from prenups to dividing assets to understanding alimony and everything in between, all with expert guidance to help you safeguard your retirement dreams. So, Jim, get started, please.
All right. Well, thanks, Patrice. Yeah, this is really kind of an uncomfortable topic. Nobody wants to talk about divorce, but it's a real thing, and it affects an awful lot of folk. And it's important nonetheless when you're thinking about the impact it has, not only on assets that have been accumulated over a lifetime, but also other resources, cash flows that we're expecting to come in as well and are being factored in from the standpoint of retirement. These days, the divorce rates are really quite high. I heard a stat not that long ago that suggested that 43% of all first marriages end in divorce, nearly 60% of all second marriages end in divorce, and a whopping 73% of all third marriages end in divorce. So imagine the compromising end effect of those divorces on what resources one might have going into retirement. It's a maze of questions and the concerns and strategies that need to be used. And needless to say, it's important to have sound professional advice, both legal and financial, to help guide one through. And it might help with eliminating some surprises down the road. So because of that, and to help us kind of unpack some of these issues, I'm very pleased to welcome Julia L. Black Esquire. Julia owns a law firm, J. Black and Associates, PLC, in Grand Blanc, Michigan. Julia grew up in Oakland County. She attended the University of Michigan, where she graduated with honors in both psychology and economics. And then she went off to the University of Iowa to receive her law degree and a graduate business degree as well. Julia was a partner in a law firm in Flint Township before forming her own firm in 2004. And for the last 20 years, her firm is focused on domestic relations law and civil litigation, particularly with small businesses. She's widely recognized for her work on qualified domestic relations orders and assisting clients and other attorneys as well with the division of retirement funds. She's recognized in the Super Lawyers magazine for the last 8 years, placing her among the top 5% of all attorneys in Michigan. She has extensive experience in domestic relations law, and it makes her an ideal guest to help explore this topic today and the impact of divorce on retirement plans. Julia, welcome to the show. Thank you very much.
No problem. Thanks for having me.
You bet. I was thinking about what the best way to start, and let's just kind of plunge right in. You know, I don't know if it's our fascination with celebrities or whatnot, but inevitably, you hear about this person or that person divorcing, and you usually hear about the discussion of prenups or postnup agreements. Can you help kind of define what the difference is there, and are they really as effective and useful as one seems to think they are?
Sure. I'm happy to discuss that. It's funny. I just want to say, when you're talking about the divorce statistics, I did a guy's 7th divorce, And after that, I sent him promptly to a bankruptcy attorney. So by that point, there's nothing left. So that's highly inadvisable. But anyway, sure. And postnups, there's postnuptial agreements and there are prenuptial agreements. They seem to be a little more used than when I first started practicing. And, I've represented former NBA players. We did a divorce that was worth maybe $50 million a year or two ago. And so some of these have very high assets. Interestingly, in those situations, I didn't see the postnups and the prenups, but sometimes you do. They didn't used to be the courts didn't enforce them as much as I think now. At least they seem a little more enforceable, although they're not ironclad. So the prenuptial agreements are used prior to a divorce. And I think they're also an uncomfortable topic for people because it's hard to say to the person. It's difficult to say, hey, we're going to get married, but I want to protect my, hedge my bet, protect my assets if things go wrong. So I've been involved in many of those situations where some people have had a lot to protect and some of them have gone more smoothly than others. I can tell you if they're definitely a tool that help, at least you've got a better chance if they're structured the right way. And there's something that people should explore, especially when you're not getting married at 20 or at 25 at the start of your career, when both of you are coming into it with maybe some substantial assets, or one person, there's a disparity in the assets. It is sometimes a little more, especially protecting with spousal support and things like that. Although, like I said, it's not ironclad. They're definitely helpful. And it's a topic that probably should be discussed at the beginning of a marriage. I would say you can't wait until the end. They seem much less enforceable when the timeline is shorter between the time it's executed and the marriage. They definitely look at that. Courts look at that, whether you feel coerced. Both sides should absolutely have an attorney. If you draft a prenup and want the other side to sign it and they don't have an attorney, there are many cases where they have not been upheld. So I always tell the person, if I'm drafting, whether you or not, you have to give your soon-to-be spouse the funds to go get an attorney or not, you should do that. So I would say that regarding prenups. Regarding postnuptial agreements, they're not as widely used, but there's something that I think people do not understand very well. Postnuptial agreements, usually people come in and they want a postnuptial agreement. I had somebody come in a few months ago. They wanted one because they're contemplating divorce. They are not enforceable if you're contemplating divorce. So it's kind of counterintuitive because you assume people are asking you for a postnuptial agreement, which is after the marriage, because they're thinking things are shaky. Postnuptial agreements are not enforceable at that point in time. So I think it's something you should think about. Let's say you are inheriting some money and you want to segregate, with your financial advisor some money, or if you, come into a settlement of some sort, or you're worried that somebody maybe has some mental health issues or something like that. But as far as if you're contemplating divorce, they are not effective.
Okay. So they're more effective than just simply segregating those assets?
I think it helps. I think it definitely helps. It shows the intent. When you segregate assets, once you're married, really, most assets are considered marital. If you want to segregate assets, this is the best advice that I can say. Your best chance of being able for them to be considered separate property is not to commingle them whatsoever. First of all, you don't put the other spouse's name onto it once you receive the asset. Once you start dipping into that asset, which people just frequently do, they have, we're going to make home improvements. Well, you're both living in the home. You've now commingled the asset. People don't realize that, or, they pay certain things. As soon as those things have anything to do with the spouse and the marriage whatsoever, and it could be pretty tangential, there's a pretty good argument. Every judge is a little bit different, and courts are courts of equity as well. But there's a pretty good argument that the assets have been commingled. The other thing is, once you add to that asset, this is something that I think people don't understand. So let's say I have my account with $100,000 somewhere, and I say, well, now I've been saving more money. I'm going to put it into that account. Do that in another account, not in the account that you have separate, because there's a difference between passive appreciation and active appreciation. And you have a much better chance keeping the asset separate if the asset has what they call passive appreciation, where the asset has just grown because of the asset, not because you're adding capital to the asset.
So looking at this, just so I'm clear, husband and wife, let's say the wife has assets that she had prior to the marriage.
Yes.
And they're both working and they're both participating in their own 401ks and all of those kinds of things. And she has some additional monies she wants to invest. It's better to open a separate account, invest that, because the earnings then that were earned during the duration of the marriage are considered marital assets as well?
Well, if the account is separate, you have a very good chance of saying they're just passive appreciation. But
Gotcha.
once you've added things that you've accumulated during the marriage to that account, you've commingled that asset with assets that you've accumulated versus the other account where you've kept separate. And now the appreciation is no longer just passive. So
Gotcha.
I would always recommend opening a separate account rather than commingling that account. It's something people should, especially when they confer with a financial advisor, indicate, yes, I have this account, but let's start another account. That's the best way to handle it.
Okay. So for folks that are in a marriage, if one of the spouses is receiving lifetime gifts from her or his parents, it's better to have that account titled in the one spouse's name only.
Absolutely.
And as long as there's a paper trail of that, because that account would appreciate over time with every yearly gift, but as long as there's a paper trail that would effectively show that the assets have been accumulated directly as a result of those gifts and nothing more, there's a better chance of claiming that as a non-marital asset?
Absolutely correct. And you want to make sure that the gifts, when the gifts are given, that it's very clear the gifts are given to one spouse, not both. We hear those arguments a lot. Well, the gift was to both of us. Yes.
Right.
The way you explained it is the best way to do it.
Okay. So it's really funny. It's funny how people think about money, right? So when you're sitting there and you're meeting a couple for the first time and you're looking at their assets and you're doing some form of a discovery interview and you're getting an idea of where the money is and how the money is titled. To me, it seems like it cuts one of two ways. It's either everybody from the get-go had everything kind of jointly held, what's mine is yours and yours is mine, or even couples that started with very meager means have always somewhat kept things separate, where the one spouse will have his or her accounts at work, and his or her investments outside of work, and the other spouse would do the same. And then they might have a jointly held, we'll call it marital account, where they're each sort of responsible for contribution to cover some of the, let's call it, marital expenses. We have mortgage, insurance, property tax on the home, which is jointly held. We have food expenses, those kinds of things. So it's almost like they're sharing as a roommate the cost of operations, but they're keeping their investments separate. Are they as protected as they think they are?
Absolutely not.
Exactly.
No.
Because those assets that are growing through work are growing as a result of income that was produced during the marriage.
Correct.
And that gets kind of clawed back into whatever that broad calculation is that's used in terms of dividing assets. Isn't that correct?
That's correct. I see exactly what you're saying on a daily basis.
Yeah.
It does seem like some people have everything together or they have almost everything apart, live it almost as roommates with expenses. And they say, well, they come in and they say, well, these are my accounts. These are his accounts. This is and we're like, actually, it's all marital. And we see it a lot with debt. People accumulate. They're like, well, I had no part of that debt. Well, actually, you're going to be paying for half of that debt. So people need to be a little cognizant of that, regardless of whose name it's in. If it's something that's been, unless it's, somebody went out gambling and, we can show that it's just theirs, then there's an argument. But most of the time, the debt is split equally.
because regardless of who took the loan out or who is ultimately responsible for the debt, assuming that the other spouse didn't co-sign for it, the argument is those proceeds, the use of that debt was probably used in some sort of marital. We added to the house, we improved the house, we enjoyed a vacation, we replaced vehicles, or whatever the case is. So the result of that, the use of that money effectively claws back. So it's not like, well, this is your debt, this is your thing, this is my thing. It's nice and even. It doesn't work quite that way.
No, it doesn't.
Okay. Ergo, the need sometimes for maybe prenups and postnups. Since it seems to me, as just an observer, it seems like the divorce, at least the split of assets, seems to be fairly formulaic within reason. I mean, everybody wants to be equitable, but every judge's definition of equitable is a little bit different. But to a large degree, there doesn't seem to be that much wiggle room there. Is that one of the reasons for these pre and postnups to agree contractually to a settlement that through the eyes of the court might not necessarily fit the definition of equitable? But as long as it was agreed and it was a legal binding contract, then the court has to kind of go with that? Or do judges sometimes step in and say, wait a minute, this is so inequitable, this is so far off the mark, we need to do something different?
They absolutely step in and say that. I would say in almost every prenup case I've had, they haven't gone exactly according to the prenup, where we usually negotiate outside of court because there's a risk. And there's wiggle room. There is definitely wiggle room. They are not ironclad, in my opinion. They help, but there's other things you can do that maybe are as helpful, although maybe not with an alimony case, but where segregating assets, doing things like that. If you think you're going to accumulate a lot, sure, they definitely are helpful, especially, I think, prenuptial agreements, because it says, I started this account. I want this account solely is mine, and it helps define it better. But there's wiggle room.
Yeah, I would think that there's probably a greater use of prenups, and you alluded to this, when marriages are a bit later in life, or where it may very well be a second marriage, where now I already have a set of children, you already have a set of children, we might have yours, mine, and ours, and as a result, we're looking at doing certain things with our lineage that might be different than what you're planning on doing with your lineage. So that's where I think that becomes a little bit more commonplace. Is that true?
So I don't think it's necessarily true, but I think it should be true. Your analogy is how I would expect it to see it.
Yeah.
It's not how I always see it. Although there are certainly some cases, and that I do see that way. It's very interesting, but we see a lot of younger couples where the parents seem to have some means, or one side has means, and then they come in doing it because the parents are like, wait, let's protect it. They're not necessarily the people. I'm working on one right now where we were just saying yesterday, this prenup doesn't really benefit him at all. And I can analogize it to like funding, like people who have trusts, because we do some trusts and estates, right? So if you have a trust and you don't, quote, fund the trust, put the assets in the name of the trust, they're not worth the paper that they're printed on.
Right.
And people don't really understand that. Well, with this prenuptial agreement that we were looking at yesterday, he hadn't done what he was supposed to according to the agreement with, about how he was supposed to keep the assets. So it doesn't even help him. But yes, the way that you indicated, I would think with marriages that start a little bit later, when you have assets, or people that have a lot to protect, or when you want to have second marriages with children, that's the most sense that it makes. Just not always where we see it.
Well, I would have thought that was the case, only because we see it on how we're structuring equitable, that's air quotes, equitable distributions through beneficiary agreements.
Right.
His IRA, her IRA, she wants to provide something for some of his kids, but not to the same extent as she's providing for hers, and vice versa. And it becomes really kind of this long drawn out negotiation where let's try to keep everything as equal as possible. And unfortunately, in many cases, it's just nearly impossible to have things just quite that equal. So I can only imagine what it must be like if we're trying to uncouple this relationship in resources and assets.
It is definitely more difficult at that point in time. So we say, if I did criminal law, I think criminal lawyers see maybe not the best people, but on their best day. We see good people, but on their worst days.
There you go. So we talked a little bit so far about prenups, postnups, kind of how to structure title assets that might provide the greatest protection or strength going into a divorce. Unfortunately, there's still a high percentage of couples that take that next step and start dividing assets. I'm amazed when I talk to clients or get involved where the client thinks it's just as simple as we're dividing this. I'm taking this account, dividing it in half, or I'm taking this account, dividing it in half, without real knowledge of what type of an account it is. It's just not as simple as, okay, I owe you half of my IRA. Let me take a distribution and provide that. We've been on the back end where clients present themselves to us after they've already made a mistake. And you see the incredible amount of tax exposure and premature distribution penalties by not doing things the right way. And depending on what kind of a retirement account we're talking about, IRA versus, let's say, a 401k or a thrift plan, the structure is quite a bit different. Why don't we start with IRAs? So there clearly are certain ways to transfer those or parts of that, and there are ways not to. Why don't we explore that for a minute or two?
Sure. And also the difference between IRAs and Roth IRAs, which people don't seem to understand. I think attorneys don't understand it. It's actually mind-boggling to me where people don't understand. They try to trade Roth dollars for traditional IRA dollars, and they don't understand that they're not really like. One hasn't been taxed, one has been taxed.
They both have entirely different economic value.
Absolutely. And people trade them dollar for dollar. I was involved in a case last week where it was traded dollar for dollar. And at one point I got tired of arguing about it. My client benefited from it and I let it go because at that point I'm like, okay, fine, great. We'll take the Roth.
Well, see, that's where your economic and psychology background comes into play. You're in the intersection of all three. Yeah,
that's true.
Cool.
That's true. But so people need to be very careful to understand that just like you said, these assets are not, they think they're all the same. They're not all the same. So IRAs are mostly, they don't need qualified domestic relations orders the vast majority of the time. They just need to be rolled over. I always tell people, get a trusted financial advisor. Here, let me do, the template of a rollover, a document for you based on your divorce decree. The divorce decrees need to be written very specifically. It's too many times they're written with a broad brush of, all right, so what's the date of the valuation? What date are we using to divide these assets? You need to be very careful. And are we going to consider gains or losses till the date of distribution? That's especially probably more important with qualified domestic relations orders, which we can talk about after, or eligible domestic relations orders, where there's usually a big time lag. The market can go up or down so much. And you want the other side, I would think, to bear in the risk. A lot of times people insist they want a flat amount. The market plunges, you still owe half of what that initial amount is. So with IRAs, I think the important thing is figuring out exactly what your division date is, going to a trusted financial resource saying, hey, let's divide these where it gets transferred to an account in the other person's name. So there's no tax implication. And then at the time of transfer of these things, you can get away with, and I'm sure you're aware, but I don't know if your listeners are aware of the 10% penalty for early withdrawal. Whatever you take at the time, you can get rid of the 10% penalty, and you can't do that down the line. So if you need a small distribution, I would never advise taking it all, but everyone has their own financial needs. You need to be aware of what your tax implications are, because you're still going to face the tax no matter what, whenever you divide the asset. But the 10% penalty, only at time of divorce are you going to be free of that for just that small window.
Very good. Yeah, and then the transfer itself, the documentation, normally it's either a separate document or it's either simply a checkoff on the document that indicates that this transfer is incident of divorce. So everybody understands that this is kind of why we're doing what we're doing.
It definitely needs to say important. That in that, like you said, in the document, and sometimes you just separate court order, but the judgment of divorce should be clear. And often the financial advisor will need that, as well as the checkoff list or form that has to be executed by both spouses. But it definitely needs to say it's incident of divorce.
Yeah, some of the divorce cases from the financial end that have taken the longest to finally settle, where all the assets are where they need to be, everything's kind of trued up, is where the divorce decree will have divorce and the splitting of the assets as of a particular date. But to your point, makes no reference of, are we effectively truing up gains and losses? So are we talking about 24 shares of Apple, or are we talking about $4,200? Right. Because I can give you those same shares that you'd be entitled to as of that date, but with vastly different valuations.
Correct.
And then that's like, oh, I guess we all have to go back to the judge and kind of figure this thing out again. And then it takes longer and longer. So really, really, really good point. So in our practice, we work primarily with engineers, executives, scientists within the mobility technology area. So think of that as folks that work for the auto companies, the big airline companies, and defense contractors. Most of our clients accumulate well over $1 million. Most of our clients do it the hard way, which is 35 years of savings in a corporate plan. There's no big liquidity event. They didn't sell granddad's company that he started 50 years ago. And as a result, the bulk of their wealth is in 401ks or in some type of a thrift plan. Now, splitting 401ks is actually even different than splitting IRAs. So why don't we talk about the quadro?
And it's funny, quadro. To me, it's very strange that most domestic relations lawyers don't do quadros. They call them QDROs, qualified domestic relations orders. I think, in my opinion, everybody should know how to do them, because if you're doing the divorce, you should kind of know how to separate the asset. But you have to make sure that you go to somebody who really knows what they're doing. It's funny, I was in front of a judge in Oakland County some years ago, and the company, it was called Quadro something, let's just say. And now it seems like people just put that in their name. And I said to the judge, well, they've done it incorrectly. And she said, well, they're Quadro, whoever. Right. And I said, well, I could be Quadro Julia. And that doesn't mean that I'm right. You can call yourself whatever you want. And I had to go back for 3 separate court hearings to explain to this judge, because people automatically think, well, they must be Quadro experts. Absolutely not. Quadros are a separate court order. People are always unhappy at the end of their divorce. They think they're all done and they've paid. And then they're like, well, you're going to incur other costs for a quadro. So quadros are governed by federal law, not state law. So so let's say you've got a fidelity plan, you're an employee at General Motors.
Sure.
People think, well, the judge approved it, so it's good enough. Not true either. So the plan gets the final say because, again, federal law trumps state law, and the plan guidelines are what governs. So after I try to enter them at the time of the divorce, so everything's done at the same time, sometimes you get some resistance. I highly suggest, if they can be done at the same time as the judgment of divorce, that people do them. Too many mistakes get made. I've seen them where people come 10 years later, they haven't been done. People don't understand because they haven't used the money yet, but they don't have it. Somebody retires. It turns into a very large mess. So the closest in time that you can do a quadro to your divorce, the better. And they are a separate court order that explains what you're getting. Well, it should explain what you're getting, right, and at what date it's valued, and whether or not there's gains or losses. If you're doing a quadro for a 401k, pensions are a little bit different. Then you talk about joint survivor rights and things of that nature. And that has to not only be signed by the parties and the judge, but it has to be approved by the plan. And the plan can reject it. And if they reject it, they might tell you what's wrong and you do it again. I mean, the longest one I ever had, I think, was with Disney. They were horrible. It was, just horrible to deal with. I guess at the time, maybe they were sticklers. They had approved one. Sometimes they'll do a pre-approval process, so you know it's good to go. I had it pre-approved and then they rejected it. They said, what else do you want from me? But it was 4 times. So people get frustrated, and some of these things take a long time. So every plan is different. Best thing you can do is make sure that the plan documents are given to whoever's preparing the quadro. Give them your most recent statement. Make sure that they have all the information. And then if you're the recipient of the money, it's going to get rolled over, but you should make sure you set up an account with someone that you trust so that your money is taken care of, rather than have the tax implications of taking it in cash and being very surprised at what you're left with.
Very good. And just for those who are listening, the whole reason for these quadros is if you're trying to split these types of assets equitably, it's over the course of the time that the couple were married. So you might very well have somebody who's been with, let's call it General Motors, for 35 years, and they have X number of dollars in their 401k. Well, there might be a judgment that assets are being split, but wait a minute, it's not all those assets, because he's only been married to his spouse for 15 years and he already had a sizable balance to start with. So it's a 50-50 split of those assets that were accrued kind of during that period of time in the marriage. And it gets really complicated.
It's true. We call it the marital coverture. That's what it is. They get half of the marital coverture.
Right.
I want to add something based on what you said, because we came across this quite a bit, and plans should absolutely be able to go back at any value. But we came across some situations, and it was actually when one of the examples I have is when General Motors went to Fidelity, there was a lot of the back numbers were lost. We couldn't go back and figure out what it was. Good advice I can give if you're coupling is to know what your assets were at the time of marriage. Very helpful. Again, it might be an uncomfortable thing, but even if you just keep the statements from around the time of the marriage, very helpful in case something does go wrong. And you see it in the really long-term marriages where sometimes they can't go back, and they should be able to, but sometimes they can't.
We had a case like that 20 years ago or so, and client was under a quadro. I said, well, do you have any idea what those numbers were? Well, we never did it. And this was a marriage of 15 years in the past. So I started to assemble all this paperwork, and over the duration of their marriage time, the plan, this is actually a pension plan, morphed 3 different times. They restructured the plan. The benefits accrued differently, not once, not twice, but 3 different times. So I kind of did the calculation, and he still had to have a quadro. So he had to have somebody else present this. And the number I came up with was not the number that they came up with. And I kept going back and saying, I think this is wrong. I think this is wrong. I don't think you're taking into consideration this, that, or the other thing. It took 1.5 years before they finally got a quadro number that was pretty darn close to the number that we came up with because of these iterations. So you really need somebody who has somewhat of a financial background, who understands the law and understands how these things work. My experience also is, you really need to have an attorney who understands this well and can fight on your behalf, because the judges, I don't think, are going to raise a whole lot of stink based on the numbers that are presented to them. Whether the numbers are way off or not, if there's nobody arguing the case, more than likely that gets entered into the decree.
That's true. There's too many cases. They don't delve into the specifics. Yeah. They get a very small snippet. I think maybe 2% of cases go to trial. People come in and always think they're going to end up with a trial. They don't. Most cases settle out of court or at mediation or things of this nature. And once they get to the judge, they're pretty much rubber stamped unless something looks really egregious, and they're not going to take the time to do the math. They're going to expect that somebody else did. And that's why I think mistakes are made often, much more often than they should be.
Mm-hmm. It's good that there are folks who have built careers around this, such as yourself. Well, we talked about splitting assets. So the last area of resource that we need to talk about, I suppose, is alimony. Not every divorce has alimony. Based on your experience, when is alimony typically granted? And is it typically something that's granted for a finite period of time, or is it kind of a lifetime alimony? Again, you see these celebrities who are granted these huge monthly income streams, and you just wonder how that all came about.
So alimony is probably in domestic relations law the most not tangible, intangible thing that you can deal with. Some other things are much more formulaic. Let's say child support. There's the Michigan child support formula. It's pretty formulaic. Here's the income. Here's the other person's income, or we might impute some income, but it's much more by the guidelines. Assets and debts, the way we split them, much more standard. Alimony is all over the board, as we call it spousal support. The law changed on spousal support. I think it was 2018. It was around that time.
December 31st, 2017, beginning of 18.
Exactly. Yeah. So for 2018, it was changed.
Yeah.
Yes. And the way that was important is for payers and for payees. It used to be where it was taxable to the recipient and it was tax deductible to the payer. It is no longer taxable, or unless you're grandfathered in. And there are cases like that where when we modify it, we're very careful. I was involved in one recently to keep the same tax status for my client because they certainly wanted still to have the tax deductibility. They were the payer. But now it's not tax deductible and it's not taxable if you're starting anew. So it definitely has a different kind of impact because the payer is paying out of net dollars rather than gross dollars. And the recipient isn't having to pay tax. Most of us pay tax on all of our income, right? So they characterize it the same as child support, which is not, taxable or tax deductible.
If I could stop for a second. So I'm so glad you brought this up because it's a question I've been meaning to ask. So if we look at how alimony was structured prior to January of 2018, where the payor would have the deductibility, the payee would receive it as income, versus how it is today, which is completely flip-flopped. Would you say, again, this is hard because we want to adjust for inflation, but generally the alimony amounts, because we're talking net versus gross, have those then dropped a bit? So the accounting for the taxation is being reflected in the size of the payment?
I think they've definitely dropped a bit. And there are quote alimony guidelines, spouse support guidelines, although some judges don't consider them at all. Some look at them to a certain extent. I know one judge that says, I'm going to look at this formula and do 80% of it because I think they're too high. I know one that says, we're not using them at all. That's not what the law says. I know some that say, well, they're kind of, okay, this is a formula. So it's really all over the board. But I don't think that they've dropped quite proportionally to as much as you would think. They've definitely dropped, but I think, just in my opinion, I don't think they've dropped maybe by a third or whatever the exact tax consequence.
A follow-up to that. Have you seen, because for the payor, the alimony becomes less attractive, have you seen some of the divorce settlements getting restructured where there's a greater division of assets? I'd rather give the X more assets so that I don't have the burden of paying this alimony in the future. Is there a bit more of that? There's a bit more horse trading with respect to that?
So I have very big discussions with our clients about alimony because it's a tricky topic, but I'm a math person, so I like it. But so alimony can be any duration depending on the marriage. So we can go back and talk about that, but any duration, any amount, and it can be finite for a certain length of time, or it can be in perpetuity, or it can just be simply modifiable. Here's where people need to be, to your question. It's very important. Don't give the assets and restructure and just say, okay, there's no alimony. If you don't have what they call now Staples language, there was a case, Staples was the name of the case, where if you don't have that language in there saying that alimony is forever barred, and it talks about that both parties, and I ask in every case where people are testifying in their divorce day, do you waive your right to statutory modifiability? And I ask both sides on every time. If you don't do that, even if you say there's no alimony, alimony can be reopened at any time. So it's very important
Oof.
to have the language barring it forever if you're doing some sort of negotiation that neither side is getting alimony.
Because otherwise there could be a situation where somebody is, in lieu of alimony today, sharing a greater portion of their liquid net worth, only to find out down the road that alimony's come back in again.
It certainly could.
Oof.
It certainly could, where somebody says, well, I can no longer support myself. I'm now sick. I'm going back. And this spouse is on with her life 10 years later, and there's an alimony petition, and alimony can absolutely be brought back at any time without this, quote, staples language. Very, very important if you want a non-modifiable agreement. And it's also, you need to be very careful with these non-modifiable versus modifiable agreements. Like, everybody has a different psychological makeup, right? I think if I was going to pay spouse support, I'd bank on myself and I'd want a non-modifiable agreement, and I'd want to know exactly what I'm paying forever. However, you have to be careful. What if you lose your employment? It is when it says non-modifiable. So you can have non-modifiable, even not even just for a zero, but for, I'm going to pay you $2,000 a month for 5 years, non-modifiable. I had a gentleman come back in and we talked about it, and he was making a lot of money, and he's like, good, I don't want her to go back after it. Well, he lost his job.
Oof.
And I said, I can't help you. And he was like, I can't pay it. I can't pay it. There's no relief from that judgment. So just so people are aware, there is no relief at that point. You bargained for the non-modifiability. You owe it. I know they can't give blood for maternity, but they're going to keep going after it. And you could be in contempt of court, and there could be a show cause hearing against you. You owe it. So if you're going to bargain for non-modifiability, make sure that you have the asset somewhere, or you can pay for it. So you have to be really careful. I can see it more on a short term. I think it's very difficult on a long-term amount to say non-modifiable. Although I like that as far as they're clear, because modifiable, then you make more money, you can end up paying more, you hit the lottery, you've got a bunch of money. That's always the analogy that I use. So people really need to very carefully examine modifiability versus non-modifiable on both sides, the recipient and the payer, and their situation.
Excellent. Great. So when we think about cash flow in a divorce situation, we think about alimony. That usually comes to mind right away. I'm surprised how many people don't understand that they can actually claim Social Security against an ex-spouse, which when I first heard about that 40 years ago, I thought, this can't be the case. And I know the one gentleman you just represented who went through a bankruptcy, but was married 7 times. I'm sure that not every one of his ex-spouses was married to him for 10 years. But imagine there might be a whole gaggle of ex-spouses out there all collecting Social Security on their ex-spouse. You want to make a couple of comments about that?
Sure.
I find that really interesting.
And it is really interesting. That scenario came up last month. We had a client that was divorced, was entering retirement age, just started getting Social Security. We couldn't figure out why it was so low. They came back in to modify their alimony. He had retired. And I realized she was not collecting off of his Social Security. And she could have been. And you can't go backward.
Right.
They can change the election going forward. They were able to do something with it. But she lost out on a lot of money. He was the primary breadwinner. And that's another consideration, because you mentioned the 10 years. I've had situations where people are at the 9-some-year mark, and I say, we need to stretch this out to the 10-year mark. It doesn't hurt him, but she needs, right. or not to be more gender neutral, whichever, it doesn't hurt the other party, but right. The 10-year mark is what's pivotal. You have to be pivotal. You have to be married for 10 years before you can collect on the other person's Social Security. But oftentimes there's a big disparity on what one person would receive versus the other. So it's important to be cognizant of that and know that you can do it. And the 10-year mark is crucial. And
you have to be unmarried at the time you claim.
Correct.
So I'm sure there are some situations where, well, maybe we push off our nuptials for a little while longer until I can continue to collect on the ex. So I'm sure there's some really interesting planning that's done on both ends of that.
That's done on Social Security and on alimony. We have many, many clauses in the in alimony where upon remarriage, and it's not always in the judgment. So if it's not in the judgment, it's not in the judgment, where on remarriage, it stops. So we see marriages get pushed off. We have people try to negotiate. Well, we want upon cohabitation. That's why I'm saying those clauses are so different from case to case. I don't think I answered your question about length of time and amount, but just to broad brush that just a little bit, you see alimony more in longer term marriages. You see it in marriages with a big disparity in income. There are a list of alimony factors. Every state is different, but in Michigan, they have the alimony factors, and you look at length of duration of the marriage. You look at the age of the parties is also important, because are you 25 or are you 55? It's different. The incomes, the way that the parties had lived prior to, and what that lifestyle was, because it's not supposed to impoverish, they don't want either party to come out impoverished. So, you might see somebody with a 3-year award, and you might see somebody with a lifetime award. And I've had people with 6-month awards or anything in between. Or sometimes you negotiate now, because healthcare is so expensive, we find a way to close out the alimony, but we'll pay your healthcare for X amount of time. So there's all kinds of different ways that alimony, spousal support, as we call it, can be dealt with.
And I would imagine also, since it's a negotiation, there may be a situation where the primary breadwinner ex-spouse might be required to maintain certain life insurance with the other ex-spouse as the beneficiary for an extended period of time.
I do it all the time to cover, in case something happens, to cover the debt. So, and especially you have an easier time when it's employer provided, saying,
yes.
okay,
sure.
They up to, and sometimes we do it in a declining balance, saying, because there's only this much left. So every year, if they want to decrease the amount of the beneficiary, they can do that. But there's all kinds of situations. But you're right. In order to get securities, especially in the larger awards, you definitely want some sort of security if you're the recipient of the award.
Right. Kind of like a net present value of forward-looking alimony payments or whatever.
Exactly. And sometimes when it's modifiable, you don't know exactly, but at least you get, where there's at least going to be some protection if something happens. And I always, when I write in those clauses, I always say that, for example, January of every year, you get to see the document again. People never exercise that. Exercise that. You don't know if the person's changed it or not. And once they're gone, it's too late. Oh, right. And this happens all the time, where people don't, if the clause is in there, I bet you less than 10% of my clients go ahead and say, oh, can I see it? See it. There's nothing wrong with seeing it. I always say, this once a year and upon any reasonable request. You never know. Those are in there for your protection, and you should know that you're protected. But the paper is only as good as, what you do with it.
Right. Interesting. Well, you know what? We started, and I said this is a really uncomfortable topic. I found this last 45 minutes to an hour really interesting and very engaging. And I think I could talk on this topic for quite some time. Let me end with this. You've been doing this a long time, decades. And you've seen an awful lot of cases, and I'm sure you've got some incredible stories. What's the one thing you see couples do which creates problems in divorce that would be, let's say, a relatively easy fix if they had just addressed some of these things early on? I'm looking for kind of a hack, kind of in the weeds. This is kind of, you see this all the time. Say, oh yeah, geez, if they had just done this would not be the problem it is today. Is there such a thing?
You mean as far as in their divorce, I
mean, with respect to maybe how assets are held relative to what they were hoping the distribution structure might look like?
I see them all the time infiltrate their inheritance. One person will receive an inheritance and they infiltrate it. They do it kind of unwittingly. They think they've kept it separate. And then they say, well, I only took out this much, or I only did but the rest of it's separate. And I understand it because they have the money and they want to enjoy it. But as soon as they start infiltrating that asset, maybe what they need to do, let's say you receive an inheritance, but in 3 different forms, but maybe 3 different accounts maybe you try to keep one separate, at least try to argue that thing has never been infiltrated. But I feel like the inheritances are always infiltrated. And then they argue, well, it's my inheritance. And you'll see people who want to do the right thing and say, you know what, it is that person's inheritance, I'm backing away. But there are a lot of people that don't.
Yeah,
and you feel badly for them, because I'm sure that their parents or whoever left them the money didn't expect it to be divided in their divorce, but that's what happens.
So let's be clear on that. If there was one individual amongst the couple that inherited some money, I'll call it $100,000, and to a large degree that's been titled separately, held separately. It's titled in the other spouse's name. It's not in a trust where they wouldn't have access to the capital, but maybe just the income. So they could have access to this money if they wanted to. And somewhere along the line in their marriage, they went into the account and they pulled $10,000 out, and they used that within the marriage. They bought furniture. They used it as part of a construction loan. They took a big trip. That other money that's there, because they took money out that was used at the marital level, it's like the seal has been broken now on the rest of that money.
Correct.
Is that what I'm hearing?
That's what you're hearing.
Yikes.
And that's what people don't understand. And they said, well, no, I only took this much. But they seal, like, it's a perfect example. Your example is exactly right.
Wow, that's really, really scary. So if there was some family that was giving money to their children and they were concerned about that, probably the best thing to do would be to give that money via some type of a trust where one of the members of the couple wouldn't have direct ownership, might only have access to income off the trust, let's say. So the corpus, since they wouldn't have ownership of that, the corpus would still remain outside the confines of the marriage, right?
And what they need to know, though, is then you still have exposure for spousal support, because then you have more assets and more ability to pay.
So the assets held outside, whether you, if those assets are intended for your purpose only income-wise, that income stream is then built into the calculation for spousal support.
Yeah,
Boy, there's no way to beat the system.
It's pretty difficult to beat the system. I should say, and I didn't say this with a spousal support, and people should understand, ability to pay is one of the big factors, but also so is need. So people should keep that in mind. I have many people that come in and say, well, I want this very large number because so-and-so got this very large number. But the problem is, I had a very frank discussion with a client last year where I said, you're not going to get it. And she was very unhappy with me. And I said, I can't go and tell a judge who lives in the same county as you, that has more children than you, that I know what his salary is, that you need much more than what I know he has to operate his household. And so, well, that's what I should get. And I said, but part of the factor is need. And just because, and that's why, so-and-so makes, X amount of dollars, although they don't want to impoverish you, you certainly don't need $25,000 a month to live in Genesee County. I mean, you just don't need it. So you're not going to get it. So people need to keep that in mind as well, just to be a little bit realistic with their expectations.
Mm-hmm. Okay, very good. Well, listen, Julia, thank you very much.
You're welcome.
For the hour. I know you're very busy. We appreciate the time you've given us. The information was incredible. So thank you.
You're welcome. You're welcome.
There was so much in this conversation, folks. It was fantastic. Julia, I do hope we can get you back again. Jim, you had some great questions in there. Thank you very, very much. And as you've heard, divorce can have far-reaching consequences. We have highlighted the critical importance of understanding how it can affect your financial security and some steps you can take to protect your future. But remember, while the emotional toll of divorce is significant, the financial impact, that can be just as life-changing. So we hope today's discussion equips you with the knowledge and resources you need to navigate these challenges and ensure a stable, fulfilling retirement. Please be sure to subscribe to the Retirement Engineer podcast so you don't miss future episodes, and follow @Kaydan Wealth on social. Let us know what you think in the comments, and please share topics you'd like us to discuss in future episodes. Following and sharing this podcast helps our show make a larger impact.
Thank you for listening to The Retirement Engineer with Jim Kruzan. Click the follow button to be notified when new episodes become available. Visit our website at www.kaydanwealth.com or give us a call at 800-638-6900. The information covered and posted represents the views and opinions of Jim Kruzan and this episode's guests, not necessarily those of Kaydan Wealth Management. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.